Mr. Ballard? Good morning.
Good morning, Your Honors. Yes, for the record, my name is David Barron, and on behalf of my client, Larry Sherman, I really would like to thank this court for the privilege and opportunity to be here today.
It's a pretty simple case, isn't it? We look at this and say there was enough or there wasn't enough.
Boy, I had a great intro, Your Honor.
Well, go ahead and do the intro.
Give us the intro.
That's quite all right.
Either the word rape covers it, or the word rape, some people may think something's a rape that really isn't a rape at all.
I would agree with the
You have to
second
be
half
more
of that
precise.
assessment, yes.
Well, that's your side of the case.
Yes.
Your position is that the word rape does not suggest penetration. Isn't that it?
Doesn't necessarily suggest penetration, yes, Your Honor.
How old was this defendant? He was
He was
competent?
25 years old with an
Competent.
11th grade education, and I will concede there's
No
no
mental
suggestion on the record
disabilities.
that he was not competent. But I would also contend that competency, whether he was competent or not, is a non-issue. The issue is, has been stated as far back as McGurk and then again in Colantoni, there's three ways for the record to sufficiently establish intelligence, understanding of the elements on the record. Either the judge explains the elements, which clearly did not take place here. Defense attorney states on the record that she explained the elements, clearly did not take place here. My contention is the third one was not met either, that the facts, as stated by the prosecutor, did not suffice for the elements of rape. But there's I'm sorry.
Well, the prosecutor said about the case that the defendant raped the victim when she refused to engage in sex, and she ran away naked from the waist down with a T-shirt around her neck. Isn't that basically...
That's the facts, correct. So either this court needs to find that rape is self-explanatory, or that the facts plus there sufficed for a necessary finding that sexual intercourse took place. The evidence that, or the information I presented in my brief unequivocally establishes that rape is not self-explanatory. The Commonwealth has recently informed me that it's going to rely on Commonwealth versus Morrow to say that rape is self-explanatory. Morrow is completely distinguishable, Your Honors. In that case, the defense attorney in that case gave a recitation of facts. His client then admitted to those facts. Then the Supreme Judicial Court in 1973, in its opinion, summarized those facts, as stated by the defense attorney. In its summary, it used the word rape. By no means is it clear that rape was what the defense attorney stated
But
in
you
that
got
case.
a little something more here, don't you? Because he admitted as true the victim's statement, which was recited to the court, that he took her to the cemetery, forcibly raped her when she declined to have sex with him voluntarily.
That's correct.
So he admits that sex was involved, and an ordinarily prudent person would understand what that meant, including penetration.
First of all, I don't think that, as I indicated in my brief, I don't think the inference is necessary that what he forced upon the victim was sex. It's a reasonable inference, but I don't think it's the only reasonable inference. One could force something on somebody in response to a rejection of sex other than sex. But even if that is the only reasonable interpretation, that what he did was he forced sex on the victim, the information I presented indicates that sex is not necessarily meant to everybody as intercourse. The Journal of American Medical Association articles that I've submitted indicates that sex means many things to many people. Now, I won't disagree that intrinsically
When he moved to withdraw this plea, was this supported by an affidavit of any sort?
there was an affidavit submitted
But
that
it didn't
dealt
address
with
this issue at all,
Did
did
not
it?
address
I know
this
there's
issue
an
at all.
affidavit on counsel's preparedness, I could think, and some other things. But did he address this issue in an affidavit, saying, I didn't know what it meant?
No, he did not.
And I didn't do that. I did something that we can understand is short of sex. He didn't, did he?
He did not, but nor did the defendant in the Boykin case, and nor did the defendant in Commonwealth versus Cologne make such an indication, file any affidavit stating that. And it would seem that that is, as the appeals court indicated, I'm actually going to agree with the appeals court on this part, is that an affidavit would not be necessary in this contention because this contention is relying solely on the record. The record here, the affidavit would be extraneous evidence, and that would be going off the record. Now, the competency issue that was raised earlier, competency isn't one of the three things the defendant needs to show that isn't on the record in order to establish.
I agree. I raised that, and I agree with you. But you'd probably be better off, if you had somebody who was 25 but mentally retarded or something like that.
I agree. But the defendant doesn't have a burden to establish that he was sort of an idiot.
No, I agree with you. Well, the word idiot is sort of not used these days.
Okay,
Impaired.
I apologize. But the information that I presented that rape is not self-explanatory is overwhelming. In Commonwealth versus Nylander, the Commonwealth itself argued that an act that did not include intercourse was rape. Assuming that the Commonwealth is a reasonable entity, which I think we can, that is evidence that reasonable people could think that an act short of intercourse equals rape. There's also the cases of Commonwealth versus Redgate and Commonwealth versus Bratman. Now, it's important for this court to realize that I'm not relying on the holdings of those cases. I'm relying on the undisputed facts in those cases. The holding in Bratman was that one's common understanding of rape cannot trump a judge's incorrect instruction on rape. And the Commonwealth's correct in their brief that that's distinguishable from this situation. There was no incorrect instruction here. But it's undeniable that the jury in that case asked a question suggesting that it would be open to the possibility that a rape could occur without intercourse.
Yes, but that's because of what the judge said about
that is very likely.
Any penetration of any orifice in the body, right? I mean,
But there was no incorrect instruction such as that in Redgate, where the jury asked two questions concerning that. The jury asked something akin to, does rape imply intercourse? Then they specifically asked about if a penis enters a buttocks but not the anal opening, is that rape? So two questions, as different than Bratman.
but that's, I appreciate about the affidavit and you're relying on the record, but in some ways, there are ways in which the word rape, as it's legally defined, isn't what, it isn't the common sense understanding of the word. But that's not what's at issue here. I mean, we don't have this defendant claiming that, something else. And I understand he doesn't have to, but then you are stuck with the fact, I think, that there is a common layperson's understanding of that rape involves penetration.
There is no evidence on the record that the common understanding is what was used. The Commonwealth contends that since there was no suggestion otherwise, we default to the common understanding. That is inconsistent with the standard. It's a pretty high standard here. If the judge is going to rely on the recitation of the facts, those facts must necessarily imply intercourse. So if a reasonable person could think that something other than intercourse took place, those facts aren't sufficient. The Commonwealth seems to...
Let me ask you this, then. What was he pleading guilty to after the district attorney reported that he forcibly raped the victim when she declined to have sex with him voluntarily, and that she ran screaming from the scene of the crime naked from the waist down with a T-shirt tied around her neck? What was he pleading to?
The facts indicate that he could have been pleading to an act other than intercourse. He could have been pleading to that act that the Commonwealth argued was rape but wasn't rape in Commonwealth versus Nylander. He could have been pleading to any type of disgusting, heinous act that is not including intercourse but could be misunderstood to be rape.
Now, he served his sentence, correct? This was imposed back in 1990.
He's currently incarcerated.
No, because he was on probation.
Yes, and he violated his
And then he
probation.
violated
He's
probation.
been classified as a sex offender?
He has not been classified as a sex offender as of yet.
Okay.
That was put on hold
Right.
Once the motion for new trial was
Yeah, okay.
successful. I'd also like the opportunity to try to distinguish Commonwealth versus Rushin, which is another case the Commonwealth indicated in its letter to me that it would like to rely on. In that case, according to the Commonwealth, forced sex was found to be sufficient for a plea. That is not what that case stands for. In fact, what happened in that case is the defense attorney, once again, read off a recitation of the facts, which included that he asked his client, so you're admitting that you forcibly had sex with the victim? And the defendant said yes. That's on page 13, exactly as the Commonwealth cites to. Previous to that, on page 312, it indicates that the judge explained all the elements to the defendant. That's one of the three ways right there. That's a fine plea right there. I see no relevance to Rushin, no relevance to Morrow. Your Honor, I believe it was Your Honor that stated something akin to what the Commonwealth stated in her argument to the appeals court, which is rape is rape. And that assumption is seemingly reasonable. But if you read the second sentence of that Journal of American Medical Association report that I submitted, it indicates that in this realm of sexual terms, including rape.
Was that report before the appeals court?
Yes, it was.
Okay.
And it was submitted to Justice McLaughlin as well. But that second sentence indicates that intrinsic assumptions in this realm are often mistaken and should not be relied on when there's extrinsic evidence to the contrary. Here, those cases should be sufficient. The Nylander and Redgate and Bratman should be sufficient to show there are actual examples, actual instances when reasonable people have thought that a rape could occur without intercourse. There's also the fact that rape is defined by statute. My sister says that's a positive for the Commonwealth. I think it's a big positive for the defense. That would show that the legislator doesn't think that rape is sufficiently self-explanatory and it needed to be defined, as opposed to other crimes such as assault and battery is not defined. And in fact, that case, that crime, was found to be not self-explanatory. The information that I've presented that rape is not self-explanatory is truly stronger than any other case where a crime has been found to be not self-explanatory. My sister also indicates that cases such as Jones and Correa and Pixley are irrelevant because there were no facts stated in those cases, and that distinguishes it from this case. But the standard isn't that if there is nothing on the record, then the defendant wins. Commonwealth v. Foster makes that clear. Silent record is not the standard. Insufficient facts is just as evidence of an insufficient guilty plea as no facts. I'd also like to point your honors to footnote 20 in U.S. v. McCarthy and footnote 2 of Justice White's concurring opinion in Henderson v. Morgan, where they both indicate that in a situation where a lesser included offense is involved, that is a situation where the elements need to be on the record, because the defendant has never received any actual document indicating what those elements are. We have a lesser included offense here. The defendant was charged and indicted on aggravated rape, and he pled guilty to rape. And rape wasn't even stated once by the judge. It was stated 3 times on the record, differently each time. Forcible rape, which would be confusing to anybody who understands what rape is. Rape simple and rape. Your honors, I guess I'll conclude with this, assuming you let me. Before the $64,000 question became a catchphrase, it was a game show and was quite popular with the intellectual elite, or so I'm told. Today, thanks to the Fox television network, we have a new game show with a slightly different target audience and a slightly different question as its title, that being, are you smarter than a 5th grader? And say what you will about Rupert Murdoch and his media agenda, his hit show has unequivocally proven that many, many people are not smarter than a 5th grader. Now, luckily for me, my argument does not rely entirely on the failures of game show contestants.
But there's a lot of 5th graders that know a lot about sex, and they don't know anything about civics, but they know a lot about sex.
And there's a lot of people, clearly, according to Nylander and Bratman and Redgate and the Journal of American Medical Association's studies that I've submitted that don't know the definitions of legal definition of rape and don't always equate sex with sexual intercourse. Your Honors, thank you so much for your time.
Thank you, Mr. Boland. Ms. Blackman?
May it please the Court, Tara Blackman for the Commonwealth.
Well, you would agree that this colloquy was a little short of perfect.
I would agree that it was perhaps short of perfect, but I would also argue that it was sufficient. It was a sufficient factual recitation in this case.
Can you just tell me how you... I'm just looking at Justice Klainer's dissent, and he says the problem is that the record, and I'm quoting, is devoid of any indication that the Commonwealth was alleging penile vaginal penetration during either the alleged rape or the sex for a fee.
And I think that rape, used in the context of the recitation of the facts here, would have lended to the general understanding of what rape is. The layman's ordinary definition of rape.
But why?
Is stated.
Because we know that this was that there are all kinds of sexual activities that could have occurred that would not necessarily mean penile vaginal penetration.
Correct, Your Honor, but a layman would not ordinarily would not equate that with forcible rape, with the term forcible rape.
But you just keep saying that over and over again, and there's no evidence of that. You just keep saying, but a layman couldn't possibly. And then I ask you a question, but a layman couldn't possibly. I mean, where's the evidence of that?
Well, at least a layman would recognize that in a minimum, forcible rape includes the act of penetration of a genital or anal
How
organ.
do you know that? There's a lot of
I
people
mean, it could
that
be
are...
forcing her to do. I mean, there was force, possibly, but you could be forcing to do.
An attempted assault,
Well,
perhaps. An attempted rape.
well, but that's what this case turns on, whether or not rape is self-explanatory.
Well, I know it. So how do we know that?
Well, because rape is generally understood, even in
But you
Commonwealth.
keep
What's the proof of that?
Well, what is the proof that any word is generally understood? It's part of, just as the word sex is generally understood to encompass sexual intercourse. Sexual intercourse.
No, it is
I don't
not.
think so.
We
I
had a
don't think
whole
so.
presidential impeachment on that issue.
I know. Over the word is.
Well,
Is doesn't mean is
Ms. Blackman,
anymore.
Let me consider Mr. Boland's argument, and again, it depends which way you're looking at this. If the assault and battery is not defined, rape is defined. If everybody knows what rape is, why would the legislature define it?
well, the legislature defines it as I think, a sexual intercourse or unnatural sexual intercourse. We don't break down sexual intercourse to say that that includes penetration, but I think that it's a given, just as it's a given, as is clear from, I think, although Commonwealth versus Marr doesn't directly stand for that proposition, in that case, all that was said was rape, but it was inherent in that penetration in the term rape was included in that case. Of course, the defendant in that case couldn't have pleaded guilty to the crime of rape, which he was found in that case of being guilty as for the principle of the crime as accessory before the fact. He couldn't have been found guilty of that if there wasn't one of the defendants in that case was not committing a rape, was not penetrating the victim. There was nothing in that factual recitation that stated that the defendant, his friend, the other co-defendant, his friend, penetrated the victim.
Could you?
Why?
I'm sorry.
And I think that is because generally people, a layman's understanding of the term rape encompasses penetration.
Could
and
you,
I think
on that point, could you address again Justice Klainer's, and I haven't looked at all of these cases, but I assume that he cites them correctly, that the appeals court at any event, and I'm reading, has consistently rejected the concept of a layperson's understanding of the elements of the crime. I mean, often, and I think that Mr. Ballard, often when we see attempts to withdraw a plea, we look at, is it clear that the defendant understood the elements of a crime? And often it's because the judge is there spelling out the elements of the crime. We don't have that here, correct? Or you have the recitation of the evidence which spell out there was penile penetration of the vagina. Or you have, I forget the third one, but none of which is here. If Justice Traynor is correct, can we just rely on the fact that a layperson, in this case the defendant, has an understanding of the elements?
I think that in terms of the layperson's understanding of the term rape in the context of the factual recitation in this case. I'm not saying that if the prosecutor's recitation in this case just stated he raped her, that would be sufficient. But I think that in the context of the recitation of facts here, which was completely devoid, the cases cited by Justice Traynor's dissent, Commonwealth versus Andrews, Pixley, Jones, they were all devoid of any narrative, of any recitation of facts. But here we have a recitation of facts.
But you don't have a recitation of the facts which includes all of the elements. Correct? You're saying that we can rely on a layperson's understanding.
A layperson's understanding of the crime of rape used in the context that it was used here. He forced her to have forcible rape after she refused to have sex with him voluntarily for cash. And I think that that puts into context the act which we're talking about. I think that it's also clear this person, this victim, was found running naked through the cemetery from the waist down with a shirt tied around her neck. I think that all of these additional facts...
I have to... Again, I think if somebody involuntarily tore the clothes off a victim and wrapped a shirt around her neck and she was able to get away, she would be running regardless of what happened. So again, I'm not sure that that fact establishes the element of the crime.
I do not think that a competent person with a general understanding of the English language would think that rape meant something other. When it was used in this context, this recitation of facts would mean something other than penetration of penetration. And I think that that we have to. That is what we should apply. The general, competent person's understanding of the term, unless we. I mean, there are three ways under Correa, and this goes back to McGurk, under which a defendant can enter a plea intelligently. One is if the elements are spelled out by the judge. One is if defense counsel represents that he's informed the defendant of the elements of the crime, and the third is a factual recitation. And if we say that a factual recitation such as was given in this case is not sufficient, then we are, I think, saying that that third way that this court has said is a way in which an intelligent plea can be given, we take that away.
Assuming that you are correct, that everybody in this courtroom would understand that rape means penetration, don't we have to look to see whether the defendant knew that?
Well, I think we apply a reasonable, objective, competent person's understanding. Before the judge, this recitation of facts was read, the plea judge determined that this person was competent. He determined the defendant was 25 years old, had an 11th grade education, and I think that those facts are clearly on the record, and they show that this person understood, was able to comprehend the recitation of facts, and should have been able to apply the same definition that anybody in this court would to the term rape as was used in the recitation of facts that was read in this case. And I think that here the recitation of facts was sufficient, even though it did not spell out the elements, because this court has said that a factual recitation is one of the ways in which an intelligent guilty plea can be entered. And I think this case is very different from a case such as Commonwealth versus Bratman or Commonwealth versus Nylander, where the judge is instructing a fact finder to apply a definition other than the common understanding of what would be applied. That was the problem in Commonwealth versus Bratman. The fact finder would be confused because they were instructed to apply a different definition that a layperson would ordinarily understand to constitute rape.
I'm sorry, I haven't read that. And what were the facts there?
Well, that was a jury trial, and the judge.
And I mean, what was the non-common? What were the facts that were the non-common understanding?
The non-common understanding was the judge instructed the jury in that case that rape could include something other than, there was indication that included something other than penetration of the victim. And in this case, there was no such indication that there was anything, that rape could include anything other than penetration of the victim. And I think that the problem in that case was that the fact finder was specifically instructed to apply a definition that a layman would not ordinarily understand to mean the common understanding of rape. So the jury would have been confused. Here we don't have such a worry. The defendant would not have been confused. First of all, the defendant in this case was not a fact finder. This was an uncontested issue of guilt. The defendant was pleading guilty to the crime of rape. And second of all, there was no assertion by anybody that rape was anything other, should be understood to be anything other than the layperson's definition of the term rape, especially used in the context that it was used here. I think that it's also quite telling that the defendant doesn't, and of course the record does have to show that the plea was given intelligently, and I grant that, but I think it is also telling that the defendant does not submit an affidavit going to the intelligence of the police saying anything other than what he could have believed rape to include, what he could have believed he was being charged with in this case. I think that if we accept under McGurk, under Correa, that one of the ways in which a guilty plea can be intelligently given is by a factual recitation, then this factual recitation has to suffice, because it is a factual recitation of what happened that night, and it includes the self-explanatory term of rape. What a common understanding of that term is. And I think that is something we have to apply unless we're willing to say, look, factual recitation is no longer good enough. The elements have to be spelled out. And that is not what this court has said in the past, and that is not consistent with McGurk. And I think that is the issue here. Also, I think that's the really only issue here. But my brother also brings up the voluntariness of the plea, which the judge in this case found was voluntary, and I think that it's clear from the record that the plea was given voluntarily in this case when the defendant answered that he was not induced or promised to, or maybe given any promises to plead guilty. The defendant had ample opportunity to say on the record that he was not pleading voluntarily, which he did not do. So I think that's clear from the record. I also think that there is no problem here with the judges, with the absence of the judge in this case saying that he accepted the defendant's the plea as intelligent and voluntary, because it's clear from the record that he did so by accepting the jointly recommended sentence. So I think the real only issue here is the intelligence of the plea, and I think that the judge was completely wrong in deciding that this did not suffice, because it would basically strip the third way under McGurk of intelligently plea being given. There's no further questions from the panel.
Thank you, Ms. Blackman. We'll take a short break.